necessarily inconsistent with how they'd already acted when there was no contract, prior under different terms. The as far as the special stipulations, I want to touch on that. This is a pretty standard real estate contract, with the exception of the special stipulations. This is a standard, contract of adhesion, commercially drafted contract. We would agree that anything in that special stipulations that is affirmatively stated would trump anything else in the, in the contract. The argument that something in the negative not being there, to Your Honor's point about paragraph 15, would then trump paragraph 15. We would definitely disagree with that. We would agree with the court that paragraph 15, without being abated in the stipulations paragraph, would still obviously apply.
Well, what's the exact language in the option note? Notwithstanding.
I'll go through it here, but it's special stipulations paragraph. It says the following special stipulations, if conflicting with any preceding paragraph, shall control. So that goes to my point. Basically, anything in here that conflicts with something else, yes, this paragraph will control. But this paragraph obviously can't amend the entirety of the rest of the contract, or the entire contract would just be that paragraph. It would render the entire rest of the contract completely moot, because you would say if something's not in there, then, well, this doesn't say you can't do that. So that would be our stance on that. Essentially, it would need to be affirmatively in here in order to amend something else in the contract, which is consistent with the language, the following stipulations, if conflicting with any preceding paragraph, shall control. And Mr. Alexander talks about, hey, it's kind of generous and broad. It talks about what they might even be able to do if no financing was secured. We'll talk about what it says here. It says, if tenant cannot secure financing or pay off the balance at the end of this lease term, landlord will assume the property without any obligation to the tenant. That's not this gigantic, generous option that has been represented to you. And that is my time. Thank you.
Thank you. Of course, thanks to counsel for both sides. Again, we appreciate your briefs and your oral argument this morning.